I'm going to call your case here while we're sorting out some technical difficulties on another one. So this is Atwood versus Fawn 24-105. I see that you have served notice on the respondent, and I will make another call here for Ashley Fawn. Not getting any response. Okay, Mr. Drury.
Yes, Your Honor, I'm asking for an order. I am here right now with Ms. Atwood. Why don't you scoot on over? I think the petition really speaks for itself. This is a situation where there was obviously a relationship dispute between the parties, unbeknownst to my client at the time. But she started receiving phone calls from November all the way through December, voicemails into January, and finally had enough. I have spoken with her. She's still, because of the substance of many of those calls and the voicemails, which we did submit to court and the parties, those threaten very clearly violence against my client. The respondent indicated she's found out where my client lives, works. She's contacted her family, children, indicated she knows where they are, and that she wants to confront her. It was very direct language, not just annoying and harassing language, but very clearly threatening language towards my client. And we are asking for an order, Your Honor.
All right, and I reviewed the initial petition when it came in, and then after that, you filed some additional information, including the voicemails. So I think your representation as to the contents of those is accurate, and I'm going to change the earlier ruling in not issuing a anti-harassment order, at least an emergency one, but on the basis of the additional evidence and in the file, I'm going to grant this.
Thank you.
Now, there was no prior order granted or issued, so this will need to be served on the respondent to be effective. All right, I've issued the anti-harassment order as requested, and it is effective for the next year.
Thank you, Your Honor. That's all I have today.
Thank you, Mr. Drury. There we go. All right, this is number 24-111. Mr. West's petition for an anti-harassment order against Ms. Struss. It looks like notice of this was served on Ms. Struss by personal service on April 10th. All right, Ms. Struss, are you ready to proceed with the hearing today?
It was my understanding that I would have 7 days notice before the hearing and that I could submit evidence prior. I just did not feel like I have had proper time to submit evidence for this.
Okay, so you want a continuance to do that?
I would like to ask for one.
All right, Mr. West.
Yes, she's remained in contact with me since she's been served. I've received 81 emails since Thursday, latest one this morning. I don't have any ill will towards her. I just want to be left alone. I want no harassment, no threats, and no emails.
Okay. All right, if the matters continued, the temporary order will remain in effect as issued originally until the date of the next hearing. Okay. All right, and I'm willing to do that in the interest of fairness, Ms. Struss. If you know, the 10th wasn't that long ago, it was just a few days ago, and if you want to get together some information in order to present a defense, you know, I'll certainly grant that request and just kind of hold everything in status quo until that next date. So Ordinarily, since a emergency order was issued, the longest continuance that we can issue is 2 weeks, which would mean that the hearing would be on April 29th. Is that any conflicts with that?
I can make it work.
Okay, April 29th it will be. So that's April 29th at 9 o'clock in the morning, just like this. There's no need for either of you to serve the other with notice of the hearing because you're both here and you have it. However, Ms. Stress, if you do, you can file anything you would like for the court to consider, but file it in the court file electronically, and then that way Mr. West has access to it. If you have,
I've been having a really hard time doing it electronically. I tried over the weekend and thought it would be easier to bring it in because some are video recordings and others are screenshots.
all right, if you're going to bring things in for the court clerk to place in the record, if you do that, do it sooner rather than later so they're in the record so that Mr. West can see them before the hearing, so we don't come back here in 2 weeks and he says, I didn't get to see these because they were just filed.
Okay.
Yeah, and if necessary, serve them on him if you can't think of any other way. But if you bring them in, I'm going to urge you to bring them in as soon as you can.
Okay.
Okay, and as I said, no requirement for any other service. The order remains in effect. And then if there's any allegation of violations of the order, not only is that a issue of potential contempt or penalties for violation, it could be a criminal offense as well. So Mr. West, if you believe that there have been violations of the order, the restraint provisions of the order, you can report those to law enforcement. All right, Mr. West, we'll see you back here on Monday, the 29th.
Thank you.
And there's your hard copy of the order extending.
So with these additional contacts after the fact, if I report them, she could be held accountable.
Potentially, yeah. I can't say in advance, but if there are intentional violations of the order, then yes. Okay. Let me call next Kayla Sales and Leslie Barbosa. Ms. Sales, can you hear me okay?
Yes.
All right, Ms. Barbosa, can you hear me?
Yes, I can.
Okay, and we're here for case number 24-113. And this is Ms. Sales's petition for an anti-harassment order against Ms. Barbosa. It looks like notice of the hearing was served by personal service on Ms. Barbosa on April 11th. All right, and Ms. Barbosa, are you ready to go ahead today with this hearing?
Yes, but I was served on the 11th. I wanted to submit more evidence. I wanted to submit some evidence of my own. So would that be like a continuance or something?
Well, it potentially could be. I don't know if you heard what I did with the other case just before yours, but one of the parties was kind of in a similar position. They wanted more time to be able to get ready for the hearing and submit evidence. If you're in the same position, I may consider doing that for you as well.
Well, it was just more of the fact that the Olympia Municipal, what she stated in the no contact order was that case got dismissed with prejudice. So I mean, that isn't like, I don't know what else to say. And then there's like multiple things going on with her, and she put this protection order literally on right after all of this. I have a protection order against her for harassing me for the last 6 months.
Okay.
So she only just put this on like after all that.
Well, other cases, I know what you're talking about. I did see the other case, the criminal case in Olympia Municipal Court. But the existence of other cases and their status really doesn't have anything to do with this case. So
Okay, and then also as for the what's it called? Oh, the nudes and the stolen iPhone. I also have evidence for that I never stole her iPhone. I never sent out her nudes, which my ex, he's currently in prison right now for DV and holding me hostage. So this agenda between both of them trying to get me into trouble or anything, like I have proof of that. I've also have proof of Kayla admitting to the fact that she wanted to try to make it worse as possible or try to put me in prison. And she said this multiple times. So I agree with what she said. She wants to put an end to this. So do I. But she keeps going at it over and over and over. And I'm fed up with it. So I'm not fighting this protection order at all. I want it, like keep it, because I have one against her too. I just want to be left alone just as much as she wants to be left alone.
Okay, well, if you are in agreement, in fact, if the two of you are in agreement on that, I could just issue this order for the next year.
We
and then,
are. I think she just needs to leave my boyfriend alone as well, because he just put a
Well,
protection
that-
order against her as well.
That
So
I
she
can't
just
do
needs
anything
to
about.
Her
leave.
boyfriend is the father of my
No.
kids. So
No,
we're
Well,
already
hold
then
doing
the
a family
paternity
court thing
test,
going on.
the paternity
mute
test
for
will
them,
say
please?
otherwise.
Okay, you're both muted right now by the clerk because we can't have people shouting over each other. So I'm going to give you just this one chance right now to calm yourselves down, talk one at a time, and I'll tell you whose turn it is. Don't interrupt each other or me, and we can make some progress on your case, okay? If you're not going to be able to do that, if you can't comply and comport yourselves appropriately in court, we're going to have to just do this another day after you've had a chance to calm down. I don't want to have to do that because that's a big waste of time. So, Ms. Sales, are you in agreement that you can calm down and do this properly?
Yes.
Okay, Ms. Barbosa, are you?
Of course.
Okay, so one at a time now. Starting with you, Ms. Sales. So the potential, you're muted right now, Ms. Sales. The potential resolution to this is that an order can be issued as the temporary order was issued, and it would go on for the next year, and there would be no more hearings on this case. Is that something you want, Ms. Sales?
Yes.
Okay. And then Ms. Barbosa, with the understanding that nothing about this order is going to have anything to do with anybody's boyfriend or significant other or any potential child or anything like that, what's your position on it, the anti-harassment order continuing in place for the next year?
I want it. Keep it.
You want there to be an anti-harassment order too?
Yep. Thank you.
Okay, so it would be the order that was served on you on the 11th, and it'll remain in effect for a year. Okay, so if you two will bear with me for just a moment, I'll prepare and sign that order, and then you can both be on your way, and the court clerk will give you each copies of it.
Thank you, Your Honor.